The House Committee on Election Integrity will come to order. Will the clerk please take the attendance?
Chair Smit.
Present.
Representatives Fox.
Yes, ma'am.
Outman.
Here.
Alexander.
Here.
Hoadley.
Here.
Pavlo. Wooden.
Here.
Colzar.
Here.
Song. Present. Madam Chair, you do have a quorum.
Representative Hoadley moves to adopt the minutes from July 15th. There being no objection, the motion prevails by unanimous consent. Well, good morning. Today we will be taking up House Bill 4736. Since this is my bill, I will be going to testify on that and be sending things over to Majority Vice Chair Fox. The committee will go at ease at the call of the chair.
The committee will come to order. Chair Smit, please begin when you are ready.
Thank you, Vice Chair Fox and fellow committee members. Today I am testifying in support of my legislation, House Bill 4736, which would clarify the process that occurs when there is a death of a county candidate not currently explicitly mentioned under current law. Michigan election law prescribes a process for replacing a political party's nomination or only candidate for some county offices, but not all. In the case of the candidate's death after a qualifying deadline, while candidates for county commissioners and county executives are not included, the remaining county-level elected offices are covered, such as prosecuting attorney, sheriff, all the way down to drain commissioner. Omissions of the county commissioner, likely stem from different forms of county government becoming available over the years, which did not exist when this section of law was written. These omissions create legal ambiguities and require county clerks to rely on guidance from the Secretary of State's office, rather than the clear process laid out in law for almost every other political office held. Recent examples of the issue include one in 2024 when a county GOP Allegan commissioner died the night before the election, the primary, and he was the only Republican candidate to file for that seat. Several days later, the Allegan County Republican Party met to nominate a replacement candidate for that November ballot. The decision to place this replacement candidate's name on the November ballot led to a write-in candidate to file a lawsuit, which was ultimately decided in favor of the county clerk's action. However, the circuit court judge noted that, given the lack of a clear statutory mandate, defendant Allegan County Clerk appropriately relied on guidance from the Michigan Secretary of State. Another example occurred right here in Ingham County, when a candidate died after the primary election ballots were printed. Again, this was in 2024. This situation did not end up in a lawsuit challenging the Ingham County Clerk's actions, but it easily could have, and at the very least shows that these situations are not rare. Finally, it's worth noting that both state offices, such as state representative and township offices, follow the same process as the existing county offices covered under current law. These are just a few reasons why I'm asking for your support of my legislation, House Bill 4736, which will provide much-needed clarity to fix this loophole. And it will treat all county elected offices in the same if a political party is left without a candidate following in the event of a death. Thank you for this opportunity, and I welcome any questions that the committee members may have.
Sounds like a common sense bill. Are there any questions out there?
Thank you, Vice Chair Fox, and thank you, Chair, for your testimony, and appreciate you bringing this to our attention as a former county commissioner. I always loved having to peer into two acts in Michigan law, since so much of county commission elections are in the Apportionment Commission Act that's not in Michigan election law. My one question was this. I can understand following the other manner in which county officer positions are filled in this event, but given the fact that all other county offices are always elected countywide, or county commissioners are always elected by districts. Are we not running into a dilemma where county party executive committee members who do not live in those districts will be placing someone for nomination in another district? Was there any thought to replicating what state representatives, what happens in the case of a vacancy with a state representative, where it's the precinct delegates that live within that district deciding upon a replacement nominee?
Well, I didn't look into that, but you raise a good point with that. I mean, the precinct delegates are obviously part of the executive committee, and so I would hope that that would just be the best way to come up with a candidate for that replacement.
Thank you.
You're welcome.
Any other questions? Okay, well, thank you for your testimony. Are you going to go to the next one now?
I am going to, I believe, come back into the chair. We have, I
Okay.
think, somebody online that is going to be testifying as well.
Okay, thank you very much.
Thank you.
The committee will go at ease at the call of the chair.
The committee will come back to order. Next, the committee will hear testimony from Allegan County Clerk Bob Janetsky, testifying in support of House Bill 4736. Welcome, Clerk Janetsky. Please begin when you are ready.
Thank you very much. I wanted to make sure that you can hear me okay.
Yep, we can hear you great. Can you hear me?
Yes, I can. Seems to be a little bit of a delay. I'm not sure why that is. Okay. Thank you very much, Madam Chair, members of the election committee. I can, yes, but there's a little bit of a delay.
Okay, we can hear you just fine. So if you would just like to go ahead when you are ready, that would be fine. Thank you.
Sure. Thank you very much. Members of the committee, last year, late in the summer during the primary election season, Allegan County unfortunately had a very sad tragedy. One of our long-term county commissioners suddenly passed away just before the primary deadline. And relative to that, it left no one on the ballot whatsoever. When my office and I sought the law as to how to handle such a vacancy, we were concerned to find that there was no remedy in the law for a vacancy only for county commissioner. For a vacancy in any other office, from governor on down to partisan parks commission, election law was very clear on how to handle that. Unfortunately, for only a county commission office on a primary ballot, we were completely in the dark because the law doesn't spell that out. If you look at Public Act 116 of 1954, or otherwise known as Michigan election law, death of a candidate is addressed 36 times, whether those candidates are in the primary or in the general election. Unfortunately, there's one omission, and that is for county commissioner in a primary. And so, as you can imagine, that creates a lot of challenges. It creates lawsuits, and it creates the potential for 83 different county clerks handling things in 83 different ways. So House Bill 4736 would take care of that and make the law very understandable, seamless, and make sure that a vacancy in this manner was handled in the same manner as all of the other vacancies.
Thank you, Bob, for your testimony here and helping us understand the issues that this has caused. And I think that the committee can agree that this is something that is definitely necessary. So appreciate your time and testimony here today. And we will continue to read in the cards. Not wishing to speak supports the bill. Aaron Shore, representing Michigan Department of State. Not wishing to speak supports the bill. Howard Green. Next, we will be taking up House Bill 4707. And again, this is a bill that I have introduced, and I will turn things over to the Majority Vice Chair Fox. The committee will go at ease at the call of the chair.
The committee will come back to order. Chair Smit, please begin when you are ready.
Thank you, Vice Chair Fox, and committee members again for letting me testify on this bill, House Bill 4707. This would prohibit ranked choice voting for local, state, and federal elections. Ranked choice voting is confusing for voters, and it violates the principles of one person, one vote. As we've heard from the leading national experts in this committee back in July, ranked choice voting is a non-traditional form of voting that allows voters to rank candidates by preference rather than casting a ballot for a single candidate. 2 states currently use ranked choice voting. That would be Alaska and Maine. But 16 states have prohibited the use of ranked choice voting in all or some elections. Furthermore, the legal status of ranked choice voting is uncertain in the 26 remaining states, including Michigan, that neither expressly permit or prohibit its use. Additionally, we went through a massive overhaul of Michigan's election process due to Proposal 2 in 2022. This required new equipment to be purchased and the local clerks to be retrained statewide, which added additional administrative and financial stress on many municipalities already struggling to fill vacancies. This legislation would ensure that we don't see further dramatic changes to our election before the ink has even dried on some of the massive changes that have occurred. These are just a few reasons why I'm asking for your support of my legislation. By prohibiting ranked choice voting, we will ensure that the principles of one person, one vote continues, and we will avoid confusion and additional burdens on our already stressed election administrators. We have seen, I know in just the district that I represent, many clerks that have just retired, resigned over the additional stress and time involved in all of this, and I just feel that this would really add so much more to them, especially in the rural areas and the communities, which would be very problematic of finding clerks to administer our elections. So I just wanted to make that statement out there one more time, and if anybody has any questions, I'm happy to take them.
Yes, we have a question from Rep. Wooden.
Thank you, Vice Chair Fox, and thank you, Chair Smit, for your testimony. As I was reviewing your legislation and I was reviewing Michigan election law, one thing that I recalled is the fact that we still expressively bar ranked choice voting by the virtue that we already prescribe the time and manner of each election. As we just heard from the testimony on your previous bill, we have a prescribed election manner from president all the way to Parks Commissioner. And all of them prescribe it in a manner that doesn't allow ranked choice voting. That's why the 5 municipalities that have passed their own local ordinance or ballot proposal to allow for ranked choice voting cannot enforce them because of state law. So given the fact that state law already effectively prohibits ranked choice voting, why are we putting up a bill to prohibit something that's already prohibited?
Well, I don't believe it expressively does prohibit or allow for it. So that's why we just wanted to clarify that in the election law and have it be very simply laid out that it would not be allowed ever to be utilized in state, local, or federal elections here in Michigan.
Have there been any, and then on top, was this done in response to the potential ballot campaign, the petition gathering campaign for rank by vote?
Clearly, I think that has a lot to do with it, that there's an effort here for that, so yes.
And then lastly, given the fact that that's a constitutional amendment, which should it pass, and I'm not necessarily suggesting it will or not, but should it pass, your bill would become unenforceable, is that correct?
That is correct.
Thank you.
You're welcome.
Okay, another question from Rep. Kolazar.
Thank you, Mr. Chair, and thank you, Madam Chair. Because we know there might be a ballot initiative that gets on the ballot if they get their signatures, wouldn't it just be easier just to respect the will of the Michigan voters and let them decide?
Well, I mean, sure, but we certainly have a job to do too in elections in this committee and being proactive, and part of that would be seeing what could be coming down and taking steps and measures. In my district, the last several months have been talking about this topic, and I have not heard of one clerk, local or county, that is supportive of this. So yes, it's my job as the chair of the Election Integrity Committee to advocate, to look out, and to try to put in place some parameters and structures on our laws and books that this would address. And that's exactly why we're putting this bill forward, because I'm hearing loud and clear in my district that this is not something that the locals and clerks particularly would like. So that's the reasoning behind that.
Okay, thank you. And we also have a question from Rep. Zong.
Thank you so much, Vice Chair, and thank you for your testimony, Chair. My question is, what is your response to the 5 local municipalities that already have ranked choice voting? And I know how important local control is, so a statewide ban on this process when we already have 5 localities that already offer ranked choice voting. What is your response to them?
Well, they may offer it, but they don't have to utilize that system of voting. So I'm not sure if they're using that in every one of their elections that they have, but it's an ordinance that was passed that allows them to be able to do that if they want to, but I'm not sure if they're actually using that on all of their elections.
Okay, thank you. Thank you, Chair.
Yeah, and just, again, very common sense to me, especially going along with many other states. I heard just last week quoted that 120,000 people in Michigan walked in and only voted for President Trump. And I don't know if that was an accurate number or not, but that would seem to mitigate against this idea of ranked choice voting. But going with President Trump, he has just come out yesterday saying that he wants to do away with mail-in ballots, paper ballots, do away with the machines. Wouldn't this fall in line with what our president is up to?
This would be, I'm sure, what the current administration would be very supportive of.
Okay, any other questions? Thank you very much.
Thank you.
Committee will go at ease at the call of the chair.
The committee will come to order. Next, we'll be hearing testimony from Trent England in support of House Bill 4707. Trent is with Honest Elections. Welcome, Trent. Please begin when you are ready.
Thank you very much, Madam Chair. Members of the committee, it's good to be back again. A happy coincidence that this aligned with me being in the area. But I am here in support of the bill. Ranked choice voting makes voting harder at every step of the way. It makes ballot design more difficult. It makes ballot instructions longer and more difficult. It makes voting for voters more difficult in multiple different ways, right? It asks voters to have a lot more information about all of the different candidates, right? You might say, well, I only have one candidate I like, but if you don't rank other candidates, you run the risk of being actually disenfranchised in the election. So it sort of demands that voters have a lot more information substantively, but then a lot more information about the process of ranked choice voting to not make a mistake as the ballot becomes more complicated with the addition of, the literal addition of more bubbles to fill out or not to fill out, lest you create an overvote or an undervote, as I'll describe in just a moment. And then the tabulation process is more complicated, so complicated that the whole history of ranked choice voting advocacy in the United States, going back 100 years, has sometimes explicitly and sometimes implicitly rested on the idea that voters just don't need to understand how the ballots are counted. I found this back in writings about ranked choice voting from over 100 years ago that, well, it's simple because, not because voters can understand it, but because voters don't need to understand it, right? And I think that's a terrible premise for a democratic process. The great example of all of this is what happened in California. The state of California has resisted ranked choice voting to the current and previous governor, I think, have both vetoed bills that would have expanded it, but they do allow it at the local level in California. And Alameda County a couple of years ago had an election where they made a mistake and they didn't know it. They programmed their software just a little bit off. And what happened was that they miscounted votes with gaps. Now, what's a gap? You can't have a gap in a normal ballot because you just vote for one candidate, but a gap on a ranked choice voting ballot is where maybe you don't rank anyone first, but you do rank someone second, or you rank someone first and third, but not second, right? So there's a gap in the ranking. This is a mistake that ranked choice voting makes possible. What do you do with that? Well, it's not intuitive. There are several different things. Their computers just ignored those ballots that were missing a first place rank in the first round of tabulation, but they were supposed to collapse the rankings up. And it turned out a couple of months after the election, when some outside academics were just doing an analysis, they weren't doing an audit, right? Everyone had missed this. The elections were certified, the candidates were sworn in, that these academics discovered that all of their ranked choice voting totals were wrong. and that it had made the difference in one of the elections. They had actually sworn the wrong person into a school board seat in a relatively simple ranked choice voting election. There were only 3 candidates, and so it was the voting was in the thousands. I don't remember exactly how many votes there were, but 237, I think, voters had left a gap, and that flipped the whole election, and it was caught by happenstance, right? Ranked choice voting makes it harder for voters. It makes it harder for the clerks running elections. It makes it harder to do the tabulation. It makes it harder to trust. It's the wrong way for Michigan elections. I think this is why voters in multiple states last year voted down ballot measures on ranked choice voting, and why so many states, it's up, I think, to 17 and may become 18 if Ohio passes their ban next month, have banned ranked choice voting, and hopefully Michigan will follow suit. Thank you, Madam Chair. Glad to take any questions.
Representative Colasar.
Thank you, Madam Chair, and thank you for your testimony. I'm going to ask a very similar question that I asked the chair. We may have something on the ballot if they get their signatures, so it's going to require Michigan residents to sign on to this, and then they get to vote on it. And why shouldn't we just why do we need this bill instead of just respecting the will of the Michigan voter? If the Michigan voter doesn't like it, they can vote it down, and we don't have it.
Well, I think that, I mean, this committee, this legislature acts in all kinds of contexts to make law when the voters may weigh in, certainly could weigh in because of the process that you have here. I think, frankly, that, I mean, this is a good example of an instance where the legislature speaking on the issue may be very helpful to voters because it's a complicated issue. I mean, what's on the ballot here is a form of ranked choice voting that, as far as I can tell, has never been used in the exact way that it's proposed anywhere in the world, right? Not just the country, but anywhere in the world, right? It's a very novel, if you go and read what they proposed, it's not exactly, you know, it's certainly not what they do in Alaska. It's similar to, but not exactly the same as what they do in Maine. You know, so I think the legislature looking at this and offering its view, I think has a lot of value for Michigan voters.
Representative Fox.
Yes, and thank you, Mr. England, for your testimony. I guess my bottom line question, I would love to hear your perspective on, are we in America, are we in Michigan, are we a republic or a democracy? Do we have a representative form of government, which we're talking about here, or do we have a government by the masses? Thank you very much.
You know, certainly, I think that I think we are a republic, and of course, James Madison says, you know, a republic, by which I mean a government where we use representation. He writes that in the Federalist Papers, and you know, we have all of these democratic processes. But I think the key point of departure between that idea of some kind of direct democracy and a republic is that you know, we use democracy as a process, right, within our republic to try to govern in the interest of justice and not simply in the interest of whatever happens to be the majority will at the time. Thank you.
Wonderful. Well, thanks again, Mr. England, for being here and weighing in on this. Next, we will be hearing from Jason Sneed, who representing Honest Elections Project, and he is joining us via Zoom. Welcome, Mr. Sneed. You may begin when you are ready.
Well, thank you, Chair Smit and members of the committee. I regret I can't join you in person, but I applaud your efforts to advance legislation to ban ranked choice voting. As you mentioned, I am Jason Sneed. I'm here today in my capacity as Executive Director of Honest Elections Project Action and as the co-chair, along with Mr. England, of the Stop RCV Coalition. HB 4707 is a crucial safeguard for Michigan elections. Banning the complicated scheme known as ranked choice voting will ensure that Michigan elections are transparent, efficient, and accessible for every voter. As we heard during Chair Smith's testimony, there is a national movement against RCV that is only gaining momentum. This year alone, we've already had 6 states, possibly soon to be 7, with Ohio's ban nearing the finish line, that have already passed laws against ranked choice voting. That makes a total of 17 states in the last 4 years that have passed laws to make ranked choice voting illegal, including Missouri, which actually put a constitutional amendment on the ballot in 2024 and won roughly 70% support from the voting public. When you take that with the fact that 6 states voted against ballot measures last year alone that were intended to bring ranked choice voting to their elections, I think it is starkly clear that there is no public appetite for this particular voting scheme. And as we have heard with all of the testimony so far this morning, it is abundantly clear why that is the case. This is a solution in search of, or this is a problem in search of a solution. It makes the process more complicated. The public doesn't understand the voting process itself or the process of tabulation. I think that one important point to note for legislators is that it is an extremely expensive proposition as well. Not only because you have to re-educate the public. New York City, when they used this system for the first time, spent $15 million on a program to re-educate people how to vote with ranked choice voting. You also have to retool the entire process. That means retraining your election officials. That means retraining your poll workers, because the process is so fundamentally different. It almost certainly requires you to conduct elections in a fundamentally different manner than what you do right now with central tabulation, for instance. The only 2 states that use ranked choice voting, Maine and Alaska, are forced to do this because it's not just the total number of votes at the end of the day that determines the winner, but also the order of elimination. So with each round being functionally a different election, you have no choice but to centralize the tabulation process. You also wind up hiding the full results from the public while you're waiting for every ballot to come in, something again that both states, Maine and Alaska, do to avoid essentially revealing to the public how the sausage is made. Because if you run the full tabulations, you would be eliminating one candidate in the first round, and then you would be eliminating a different candidate in the first round as every ballot comes in and potentially changes the outcome in significant ways. We have seen this complexity actually result in elections that have been declared for particular winners only to find out after the fact that the tabulation was done incorrectly and almost wind up completely undetected. We heard about the Oakland example that Mr. England mentioned. That sort of opacity does nothing except harm public perceptions of the democratic process and ultimately drive down trust in our election system, which perhaps explains why the data that has been compiled on the use of RCV actually strongly suggests that if it has any effect on turnout whatsoever, it is a negative effect. It actually discourages people from participating in the process. We've known for a long time that the most significant driver for participation is the belief that your vote will count. And what ranked choice voting turns our election system into is an algorithmic black box where you don't know whether you made an inadvertent mistake and accidentally voted for 2 people in the first place, and that invalidates your ballot. You don't know if your ballot gets tossed for some other reason. And after your ballot gets shifted down to your second or third place ranking, you ultimately don't know who, in many cases, your vote actually counted for. We've heard some discussion this morning about the question of whether the state should pass a law that would prohibit this at the local level as well. And I would emphatically say that yes, you should pass a law. We have already seen, for instance, Supreme Court cases like Bush v. Gore and related cases that have established a strong jurisprudence that states have an obligation to ensure consistency of the voting process within their state borders. With ranked choice voting being so complex and turning your system into a black box, it fundamentally changes the process in ways that would leave voters essentially, voting rights, I should say, essentially at the whims of where they happen to be living. We want to make sure that we have a consistent voting process across the state. We've also heard some questions surrounding whether it should be the legislature's policy to essentially get ahead of the ballot initiative. And again, I would say absolutely yes. The people elect the legislature to make laws in the state of Michigan. And even if the Michigan public ultimately votes against the ballot initiative, which I believe history strongly suggests they will, that still leaves the question in Michigan law of whether ranked choice voting is actually illegal. And we have already seen in so many other contexts in the election space, unfortunately, in recent years, a tendency to read the election code as essentially saying, X, but it doesn't explicitly ban Y, therefore we will try Y. We will try things like 24-hour voting, drive-through voting, and so forth. You can ask some of your fellow legislators in Texas about that experience in recent elections. So I would say that even if the public votes against that ballot measure, it still leaves the question of whether your law actually makes it illegal. And this particular bill would solve that problem before it gets thrown to the courts. As was noted, there are already a handful of jurisdictions that have passed ordinances, and it would be far better for you, the elected legislators, to be deciding whether or not ranked choice voting is going to be allowed in any elections in the state of Michigan than to leave that up to a court of law. So I will simply close by saying that Michigan should be moving very quickly towards joining the 17 other states that have banned ranked choice voting. I applaud you for taking this first step towards considering this piece of legislation. There is simply no public appetite for RCV, and that is evidenced by the great many jurisdictions that have walked away from this. In fact, we have seen in Utah a pilot program that reached a height of 24 cities trying this. That support has now collapsed down to just 4 jurisdictions that have tried ranked choice voting. Given that there is no support, it is far better to protect your system from allowing ranked choice voting in the first instance and solving that question of the ambiguity in your laws so that voters can understand very clearly whether ranked choice voting is illegal, and of course I believe it should be. With that, Chair Smit, I appreciate the opportunity to testify, and I'm happy to take any questions if there are any.
Thank you, Mr. Sneed, for your time today. I think it's important to note, too, I missed this in my testimony, but the amount of time that it takes for the results can be weeks, if not over a month, to determine the winner through this system of voting. Isn't that correct?
Yes, it is. In fact, the problem of delay is endemic to ranked choice voting. We have seen, for instance, Alaska having to wait about 2 weeks to report results. We have seen delays in New York City when they use it there. Here in my own home state of Virginia, there's only one local jurisdiction, Arlington County, that used ranked choice voting, and it was the last jurisdiction in the state to report regular election results. The reason for the delay is a point that I made during my testimony. You essentially have to centralize tabulation, and you have to count every ballot, because it's not just the total number of votes for a candidate that determines the winner anymore. With ranked choice voting, it's now the order of elimination. And by expanding the number of candidates in a race, you are almost guaranteeing that the margins in that first round are going to be substantially closer than they otherwise might be. So every single ballot has to come in so that you can understand which candidate is actually going to be the candidate that gets eliminated first. And that automatically delays the process. And then there are all of the other challenges that come with central tabulation. Another critical issue to note is that when you're trying to marry election results across jurisdictions that use different voting equipment from different vendors, that also is a substantial challenge, because now you have to layer a third-party software solution in order to make sure that equipment from HART and ES&S and Dominion can all essentially share results in a format that could be processed with that central tabulation system. So there are a lot of issues, a lot of complexities, and as you note, delay is endemic with ranked choice voting.
Thank you. We have a question from Representative Wooden.
Thank you, Chair, and thank you, Mr. Sneed, for your testimony. Thinking back to the presentation you gave the other month about ranked choice voting, if I understand correctly, the cornerstones of this are, the cornerstones of a ranked choice voting system would allow voters to vote for more candidates than there are offices to fill. The human intervention in reassigning those votes, those ranks, when someone doesn't have viability. Those two together, you can't have a ranked choice system without that. Is that correct? Someone, a voter has to have the right to vote for more candidates than there are offices allowed, and you have to have some form of human intervention in reassigning votes. Is that correct?
I believe it's mostly correct, although generally speaking, when you're doing the reallocation of votes, that's going to be done by computer. So there is going to be that act of essentially ranking your candidate as the voter, right, first, second, and third choice, and so on. And then as candidates are eliminated, then the voter's choice is shifted to their next highest selection. The point about the human intervention, though, I just wanted to make clear, that's usually done by computer and by software these days.
But regardless, the prohibition on voting for more candidates than there are offices available, that's a cornerstone of ranked choice voting, since you're voting for multiple people even though you have one spot. Correct?
That's correct. That is correct. Yes, that is correct. It allows you to rank. There are various systems, but in general, whether it allows you to rank 3 or 5 or has no limit whatsoever, it is asking you to rank and vote for more candidates than there are offices in any particular election. Yes.
I appreciate that. And the reason I ask it is, I can understand the expressed rationale, but given the fact that our state law already prohibits that from happening and prohibits the human intervention, I struggle to see why an additional bill to ban something that state law already makes impossible by taking away the cornerstones of it allowing to happen. You've made some very compelling points about why we should be concerned about ranked choice voting. I'm not sold on it, but I also am a believer that we should focus on legislation that truly seeks to accomplish something that currently doesn't exist. And I'm struggling to see, given the fact that our state law already prohibits the cornerstones of ranked choice voting to making it impossible, why the 5 municipalities that have ranked choice voting have not been able to implement it, nor, to my knowledge, have they sued for the ability to implement it, because our state law is so ironclad in how it's prohibited. And furthermore, if I understand correctly, the one municipality in Michigan that has had ranked choice voting through lawsuit, it was because of a federal suit that would have superseded any state law to begin with because of a voting rights complaint through the Department of Justice in 2017. So given those are in place, where's the value in an additional prohibition?
Well, if I may, I would just suggest that just because there has not yet been an attempt to implement it at the local level does not mean that there will not be. And in my opinion, having dealt with this in so many different states, the best response is to make it explicit in your state law, in black and white in the code, that ranked choice voting is not permitted in state law. Otherwise, what you have is not really a legal prohibition. You have an argument that will be made in front of courts. And sometimes judges do not always read the law the way that you, the legislature, do. So it is far better to take this step right now. And then as to the question of whether or not it should be left up to the voters with that initiative that is potentially going to be on the ballot next year, of course, there's no reason that the voters could not endorse that. But I think that if they vote it down, it still leaves that question of whether or not the law is actually clear on ranked choice voting. And my only point is that the people elect the legislature to make law, and it would be better left to you to make it clear that ranked choice voting is illegal in the state of Michigan, rather than leave it up to a locality and a court to make that argument and potentially prevail. We have, as I mentioned, seen plenty of examples where either whether it's a particular organization or whether it's a locality will read election codes as saying elections shall be run according to X, and then argue, but it doesn't explicitly ban Y, and therefore we will do Y instead. It's just better to make sure that doesn't happen, to head that off at the pass and provide clarity and consistency with your election laws.
Thank you.
Thank you again, Mr. Sneed. There are no further questions. We will move forward with, next we will be hearing from Harry Roth, who supports 4707, representing Stop RCV.
Hi, thank
Harry.
you. Are you guys able to hear me?
Yes, we are. Please begin when you are ready. Thank you.
Okay, thank you, Chair Smit, representatives. Thank you for allowing me to testify. I'm hopeful that the House will pass HB 4707 to ban ranked choice voting statewide. Without a law in the books banning the use of ranked choice voting, there's a risk of more cities and counties implementing it and creating distrust and confusion. Over the last 3 years, 17 states have already outlawed RCV, and there are repeal movements active all over the country. On top of that, over a dozen cities in Utah have ended their participation in the state's pilot program. Just last year, Alaska's repeal ballot measure came within 743 votes of succeeding. Another measure will probably appear on the ballot in 2026. And meanwhile, if you look over in Maine, voters there have had to deal with weeks of delays and tech issues since adopting RCV back in 2016. Locales that have adopted the system haven't fared well either. Voters in Oakland, California had to recall their mayor, Sheng Tao, 2 years after electing her due to a spike in crime and her being under FBI investigation for fraud. She only won by receiving the most second-place votes in the ranked choice voting process. And similarly, in New York City, the ranked choice voting system led to over 140,000 ballots being eliminated due to ballot exhaustion during the 2021 Democratic mayoral primary election. So when voters fail to rank enough candidates, either intentionally or out of confusion, their ballots get eliminated when the candidate or candidates they did not rank are eliminated during that tabulation process. And this isn't just a harmless quirk in the system. It ends up disenfranchising voters and it discourages voting. It also punishes principled voters who refuse to rank certain candidates that they disagree with. So we see that whether ranked choice voting is used locally or statewide, in the end, the result seems to be the same. American voters are left confused by complicated ballots. They're unsatisfied with the opaque process, and they end up being disenfranchised through ballot elimination. So thank you again for giving me the opportunity to testify.
Thank you, Mr. Roth. Are there any questions from the committee members? Seeing no questions, I appreciate your time today. Thank you. We will continue on and have additional testimony. I will ask that you please limit the comments to 2 minutes each. Wishing to speak, opposes the bill, Joe Spalding with Rank My Vote. Welcome, Joe. There's a button right there, if you could just push
Thank you for the kind welcome, Representative Schmidt. My name is Joe Spalding. I am campaign director for Rank My Vote. I just want to start off briefly by noting that the error rate for ranked choice voting is roughly the same as single choice elections, which we have now. And as someone who was alive in 2000, I feel compelled to remind the committee of 2 words, hanging chads, or maybe even 3 words, Dewey beats Truman. What does a ban on ranked choice voting prevent? What does this bill do? It prevents a level playing field. Ranked choice voting is a level playing field that favors voters, not political parties. It's used right now in Michigan in a modified form for the AG and Secretary of State primaries. It reduces post-primary inter-party drama. This is well recognized. Any candidate pursuing a nomination for these offices from a major party next year is already participating in a ranked choice voting election. I appreciate the comments from Mr. Sneed. He is also represented by a governor in Virginia, Glenn Youngkin, who won a ranked choice voting primary. If ranked choice voting is good for the party in the primary, I promise it's good for the public in the general election. Ranked choice voting strengthens the republic. In a republic, an election is a way for the people to pick a leader in a seat of power. That leader ought to represent at least half of those people. Single choice elections punish voters when more candidates run. HB 4707 effectively means that with 4 candidates in a race, a winner only needs 25% of the voters to win. Ranked choice voting incentivizes collaboration instead of partisan hatred. Single choice elections without ranking makes negativity inevitable. Young people feel trapped by their lack of choices, in Michigan especially. They come to me every day when they're signing our petition. Liberals and conservatives don't want to vote for the lesser of 2 evils. Progressives want options outside of the oligarchy, in their words. MAGAs want choices beyond what they call uniparty. Ranking is ubiquitous. It's used in video games. If you're actually confused by the concept of ranking, you need to ask a recent high school grad. If you care about election turnout and stopping changes to elections, I promise that preserving mail-in voting, despite what President Trump says, is a more effective way to do that than banning ranked choice voting. Ranked choice voting is a very simple solution to the issue of voters getting punished when they're given more choices in an election. And it favors the voters. It is absolutely imperative that we're honest when we're describing the things that we're trying to ban in this state.
Thank you, Mr. Spalding, for your time. Are there any questions from the members?
Sorry.
Representative Wooden.
Thank you, Chair. And forgive me, one quick question. You did bring up something that I hadn't thought about, which is the process by which we nominate Attorney General, Secretary of State, our various state boards through the convention process. and the fact that it does, by the virtue of it requiring a majority vote of the convention delegates, having some form of rank system. In your view of the legislation, does this put that process into question since the nomination process is also prescribed in state law?
Look, I'm not an election attorney. I think it does, personally. I definitely think that's something that the committee should consider before voting on this.
Thank you.
There being no further questions, thank you for your time today, Mr. Spalding. Next, we will hear, wishing to speak, supports the bill, Shelley Lake, representing her township clerk, deputy clerk, excuse me. Good morning, Shelley. Please begin when you are ready.
Good morning. First, thank you all for allowing me to speak today. My name is Shelley Lake. I'm a deputy clerk in Berry County. Have run elections. Our clerk was gone for several months out of the year, so I ran them. We have a new clerk, and so I will teach her now. First of all, I want to let you know that being in election integrity and involved, I know clerks all over the state. I have not talked to one clerk who wants ranked choice voting. Even county clerk associations are against it. Not one, and I talked to both parties. So I did want to say that one major concern I have, we have an absentee counting board downstairs. We ran a mock election just for fun. We voted on our favorite candy bars, and we learned that from the ranked choice voting guys. So we went and did that. One voter only wanted Hershey bars, so she ranked it first all the way across the ballot. First, because I don't want any other, so I'm going to rank it first. Well, if she had been an absentee, and that's not abnormal, go down to our absentee counting board, her ballot would be spoiled. She has overvotes. She wouldn't know that. She couldn't fix that. We have a lot of absentee, at least in our township. And I just feel like the amount of spoiled ballots is going to greatly increase, and they're not going to know about it. It is confusing to voters, and I think that it will deter them. As I hear them walking around talking about getting signatures, I listen to them, and they make it sound so good, I even want to sign it. Voters don't understand. Prop 2 is evidence of that. They didn't understand everything they were voting for, and then they regret parts of it. So I hope that the committee will move forward with this bill and not let this ranked choice voting become a part of our Michigan Constitution. Thank you.
Questions from any of the members? Thank you, Shelley, for your time today and your testimony. Wishing to speak, supports the bill, Jeff Schaefer, representing Pure Integrity Michigan Elections. Good morning, Jeff. Please begin when you are ready.
Thank you very much, Chairman Smit. There's many issues with ranked choice voting. Again, as Representative Wooden pointed out, it replaces one person, one vote with the ranking of candidates. And if someone has a strong objection and they only want to vote for one, their vote only counts once, where other people's votes counts many times. It penalizes those voters that do refuse, that have strong positions, by only eliminating or exhausting. It's a manufactured majority. It is not a majority. So if a person only votes once, their ballot is exhausted, cast aside, and so the denominator becomes less, so the numerator can become more. Hence, it's not a real majority, as same as with plurality voting. The current proposal excludes state reps and state senators, your offices. Your offices would remain plurality. My question is this: if it's not good enough for all elections, why is it good enough for any election? It relies again on election machines to calculate the winner, and as been pointed out in Oakland, California School Board and other races, the machines malfunction. Now, my professional career, I was in internal controls and an auditor, and if you can't audit a process, you create distrust. And let's face it, there's a lot of distrust of machines on both sides of the aisle, starting with 2000. We all remember the stories of Diebold, and now it's Dominion. So we're saying, trust the machine. I don't think a lot of people are ready to go there. And these races are local races. And we want to have this happen for a statewide race with the time involved. And a little aside, the New York City mayoral primary was ranked choice voting. But the general election is a plurality election. So when the rubber hits the road and a voter's getting ready to hand the keys to the city over, they want a plurality election. And again, it's been banned in 17 states. Ranked choice voting is a complex solution to a simple problem that has a very simple solution. It's called runoff elections, where the top two candidates go head-to-head if a candidate doesn't get over 50% of the initial election. That is a real majority. The choice is clear. Ranked choice voting is not the right answer for Michigan elections. And I hope you pass this bill into law. Thank you very much.
Thank you, Mr. Schaefer. Seeing no questions, appreciate your time today. I will continue on and reading in the remainder of the cards. Not wishing to speak, supports the bill, Howard Green. Not wishing to speak, supports the bill, Beth Deshone, representing Michigan Forward Network. Not wishing to speak, opposes the bill, Kay Perry. Not wishing to speak, opposes the bill, Eric Wellesby, Detroit Disability Power, representing. Not wishing to speak, opposes the bill, representing ACLU of Michigan, Gabrielle Dressner. Did you fill a card out? I'm sorry, we need to have you fill a card out prior to. Thank you. The committee will now take up House Bill 4642 and take a vote. Representative Fox moves to report HB 4642 with a recommendation it be referred to the Committee on Rules. Will the clerk please take the roll?
On the motion to refer, Chair Smit?
Yes.
Representatives Fox?
Yes.
Outman?
Yes.
Alexander?
Yes.
Hoadley?
Yes.
Tableau?
Yes.
Wooden?
Yes.
Colzar?
Yes.
Song?
Yes.
Madam Chair, you have 9 yeas, 0 nays, and 0 pass. The motion does prevail.
HB 4642 is reported with recommendation that it be referred to the Committee on Rules. Next, we will take up House Bill 4707 to take a vote. Representative Hoadley moves to report HB 4707 with recommendation. Will the clerk please take the roll?
Chair Smit?
Yes.
Representatives Fox?
Yes.
Outman?
Yes.
Alexander?
Yes.
Hoadley?
Yes.
Tableau?
Yes.
Wooden?
No.
Colzar?
No.
Song? No. Madam Chair, you have 6 yeas, 3 nays, and 0 pass. The motion does prevail.
HB 4707 is reported with recommendation. There being no further business before the committee will stand adjourned.